Welcome to our call on disparate impact, and we have a great coalition here today to talk about critical issue that will really impact our communities and access to credit and opportunity and other fields as well. We have a combination of an effort that's with the National Fair Housing Alliance, with the Urban League, with Unidos US, National Capacity, and Americans for Financial Reform. And of course, National Housing Resource Center. I'm Bruce Dorr-Palin, and we have Melody Emo as well on the line from NHRC. And what we're going to do is we're going to walk through the kind of the basic issues. So Jorge Soto from National Fair Housing Alliance will give us the overview and examples of what disparate impact means and why it's important and how it impacts on housing, and then also in broader fields as well. And then we will have how this impacts communities that are particularly well represented on this call. So we'll have Agatha So from Unidos US, and we'll have Ed Jackson from the Urban League in Buffalo. And then we'll have Linda June from Americans for Financial Reform, and she has actually litigated on disparate impact cases, and will give her perspective about creating a fair and just legal system. And then Jorge will come back to talk to us about the practical steps that each of us can take that would be helpful in trying to preserve disparate impact. So should be a good call. Thank you everybody for joining. We're going to dive right in. So let's start out with Jorge and the National Fair, from the National Fair Housing Alliance.
Great, thanks so much, Chris. I appreciate you pulling this all together into the other partners on the phone. So my name is Jorge Andres Soto, and I am Director of Public Policy at the National Fair Housing Alliance, and I'm here to talk to folks about the proposed obliteration of a civil rights tool that most of us have probably never heard of, but that's really important for a number of different areas of work that folks on the call do. So this is what's known as the disparate impact rule. But before I go into the rule itself, I need to give folks a bit of background. So this is a rule that implements a really critical component of the Fair Housing Act. The Fair Housing Act prohibits intentional discrimination as well as policies or practices that have the effect of discriminating against people of color, women, families with children, people with disabilities, and people who practice any faith. So this second piece, the ability to challenge policies and practices, is especially important because of the inequities across our nation's economy that are born from government and privately sponsored discrimination and segregation that are still baked into our systems that are used in the housing market today and in the housing market itself. So the ability to challenge policies and practices that appear neutral on their face allows us to detect covert discrimination as well, and we use what is called the disparate impact doctrine. And that allows you and me to challenge a policy or practice that has the effect of excluding certain groups of people or segregate particular communities in practice. Now, this is especially important in the aftermath of the foreclosure crisis, when the Department of Justice and states started using the disparate impact doctrine to go after banks as an effort to slow the decimation of wealth in communities of color, and from which our communities have not really recovered. So in 2013, HUD put together a rule that streamlined the ways that these kinds of complaints are brought, and it's a rule that we were supportive of and that we really helped kind of push to become more effective for plaintiff parties. In 2015, the Supreme Court affirmed the ability to bring disparate impact claims under the Fair Housing Act. And this was despite the fact that there had never been any controversy over whether those kinds of claims could be brought under the Fair Housing Act itself. And this case, as well as two other cases which settled before it, were brought primarily through the efforts of groups like the Heritage Foundation, Cato, and also financial services and insurance trade associations. So this has been kind of on their hit list for some time. They failed in the Supreme Court, and now that Donald Trump and Ben Carson are in place, we see a different regime that we're currently trying to fight. So despite all of that affirmation of the importance and the usage and the ability to use and the legality of using disparate impact claims, Donald Trump and Ben Carson are essentially spearheading a surgical attack on civil rights by making it impossible to bring a disparate impact case by changing the existing rule that was finalized in 2013. And this is very important. The proposed changes to the rule from this administration are frankly extremely frightening and unprecedented. And it's going to mean that banks, insurance companies, and big apartment rental companies will have to essentially not have to choose policies that apply fairly to all people anymore. And Trump and Carson are doing everything they can to shield these larger corporate interests in the financial services sector and other housing market players from facing the legal consequences of the discriminatory outcomes of their business practices. So HUD's proposed rule makes drastic changes to the way and institutes dangerous exceptions to this longstanding enforcement tool. The proposal would essentially destroy disparate impact liability as we know it, making it virtually impossible to bring the bedrock housing discrimination and lending discrimination cases that have been brought using disparate impact. So key provisions of the proposed rule that I really want to highlight and that I think are really kind of reflective of the intent behind the changes to the proposed rule. So the first is that the proposed rule provides overwhelming and unheard of obstacles to prove discrimination. Victims of discrimination will face a drastically higher burden to prove a disparate impact claim under the Fair Housing Act just to move forward with an actual complaint, making it virtually impossible to succeed. So victims are asked to play a rigged game of, you can kind of describe it as a whack-a-mole, trying to guess what justifications a defendant might invoke and preemptively debunk them. Know everything about their business practices and be able to explain them in detail and then offer alternate policies that could achieve the same intended outcomes of the policies that are being challenged. So essentially, you need to know everything about a defending party before you even bring a case and before you even are able to really get into the meat of what kinds of essentially how you can move forward with the case and change their policies to create more opportunity. There's another piece of the rule that's especially concerning, and this is essentially the prioritization of profits above all else. There's language in the proposed rule that suggests that a rule or policy that is profitable for a business could be immune from challenge for its discriminatory impact. And the burden on discrimination victims to show that a company can make at least as much money without discriminating. So essentially, a plaintiff party would have to bring a case and define and design a policy or a practice that would achieve exactly the same goals and profit outcomes than the policy that they're challenging in court, which is quite frankly unheard of. Discrimination by algorithm is an exceptionally concerning piece, especially as we kind of move into the increasingly digitized and data-driven housing market that we're kind of living in and kind of moving into going forward. So HUD's proposed rule would provide special defenses for business practices that rely on statistics and algorithmic systems. So disparate impact is a critical tool to rein in discrimination in the use of algorithmic models, such as credit scoring, pricing, marketing, and automated underwriting systems. And these have starkly discriminatory effects that can operate as a hidden box, making those discriminatory effects difficult to attribute to any one person's intentional discrimination at that business. HUD's proposed rule would effectively immunize this kind of covert discrimination that involves the use of an algorithm. And we know for a fact that the way that algorithms are designed tend to be overwhelmingly biased and have disproportionately negative outcomes for people of color and women as well. The last piece that I want to focus on that the rule changes is also really important when you think about HMDA and when you think about the reporting requirements that lenders have. So you essentially HUD's proposed rule says that if you don't have any data, if you're not collecting records, then you're not held liable if you're sued using the disparate impact doctrine. So businesses are actually disincentivized from collecting important data that can reveal discrimination. That means that victims of discrimination will be unable to identify whether discrimination is happening at all behind their backs and lack the ability to challenge it if they do detect discrimination, because lenders and housing providers and insurance companies can just keep their heads in the sand. So here are some kind of real life scenarios that the National Fair Housing Alliance and other organizations that use the Fair Housing Act to bring cases on behalf of victims of discrimination that I think are really revealing about the type of impact that this could have. And this is just in the housing market. So for example, a landlord could evict victims of discrimination, victims of domestic violence, because the lease holds all tenants, even victims, responsible for crimes that are committed in their home, in the leaseholder's home. We know that women are the primary victims of domestic abuse and violence and sexual assault. And this could place them and their children, if they have them, at risk of homelessness and further violence, further perpetuating a cycle of abuse. A bank could charge women, people of color, or people with disabilities who seek home loans more than others We know that given these barriers, these folks would be forced to take on risky or costly loans, or not have access to credit at all because of the historical barriers to quality and affordable credit across the country in their history. An apartment building could set a limit of one person per bedroom. We know that families are struggling, and this would force them to spend more money on housing than they need or can afford. There's no reason why two children cannot share a bedroom. People of color could be displaced from their own neighborhoods of choice due to uncontrolled gentrification that continues to creep in almost every city across America. We know that gentrifying forces have displaced Black and brown people from their neighborhoods that they built and have lived in for generations and have chosen to continue to live in. The last example, banks could maintain a practice that makes them more money even if that unnecessarily costs women, people of color, or people with disabilities more than other customers, and face absolutely no consequences. We saw this before and after the foreclosure crisis, and our economy and our communities have never been the same. So this is what Donald Trump and Ben Carson and the financial services industry and the small government folks really want to do, and really want to surgically remove the ability to enforce the civil rights laws, and this is not going to stop with housing. Right now, we are aware of plans to gut the use of this important tool in education, in healthcare, in employment law, and in other areas where we need more civil rights enforcement, not less. In fact, we're aware of a policy that's currently being drafted at the Department of Justice that would instruct all federal agencies to no longer use the disparate impact doctrine as it applies to their relevant civil rights statutes. So this is a direct attack on our ability to use the existing civil rights laws of the land to achieve justice for the people who need them. So to be blunt, without the use of disparate impact, we will never be able to meet the challenges of our nation's inequalities, like the nation's gender wage gap, the disproportionate discipline of children of color in schools, the overpolicing of neighborhoods of color, and the nation's racial wealth gap. So I've said a little bit about kind of what the disparate impact proposed rule does. There are plenty of examples of ways in which the disparate impact doctrine has been used in the lending context. It's prevented discrimination in mortgage lending. You can think about the Wells Fargo case that the Department of Justice brought post-foreclosure crisis that resulted in one of the largest settlements under the Fair Housing Act in a Fair Housing Act lending case. We've been able to fight higher insurance premiums that were essentially charged to African American and Latinx customers. That involve the use of credit scoring procedures that result in discriminatory outcomes and exclude African American and Latinx consumers from accessing those insurance products. We've been able to use it to challenge lending discrimination against mothers on maternity leave when we've had clients, and our member organizations have had clients where women applied to refinance homes or applied for new mortgages shortly after giving birth while they were on full maternity leave, where they were essentially unable to get private mortgage insurance because of their maternity leave. We've been able to halt discrimination in homeowners insurance. We've been able to challenge differential lending terms, and the list goes on in terms of the way that this disparate impact doctrine and the disparate impact rule is used to challenge injustice in the housing and lending markets. Comments are due October 18th. We are trying to get this extended, but we do not have much hope that will happen. So I'll stop there, and then I can come back to the ways in which we're currently fighting this proposed rule and ways that folks on the call can get involved. Thank you so much.
Excellent. Thank you so much, Jorge. It was excellent. So let's go to Agatha So at Unidas US. Agatha.
Good afternoon. My name is Agatha So, and I'm a senior policy analyst with Unidas US. We're really concerned about HUD's latest attack on housing opportunities for individuals and families, and of course, entire communities across the country. In my very brief remarks, I'm going to share a little bit about an overview of how we believe the disparate impact standard is important and why it's important to preserve for the Latino community as well as for many underserved and vulnerable populations across the country. Rolling back the disparate impact rule could harm the ability of Latinos to get and stay in an affordable home. The Latino community has been the center of attack on many fronts this year. Some of these attacks are obvious forms of discrimination. However, some of them are less obvious. And these less obvious forms create or make worse existing disparities. Some of the more obvious examples have come to light because of research and court rulings. According to the Federal Reserve and home loan data, Latinos are twice as likely to be denied a home loan than white borrowers. After the financial crisis, lawsuits against lenders revealed very intentional, planned methods of charging Latinos and African Americans more for their loans. One outcome that may have less obvious causes is the incidence of high-cost lending. For example, between 2007 and 2017, the percentage of Latinos receiving a loan with a higher interest rate decreased from 25% in 2007 to 20% in 2017. Yet, Latinos were still more likely to receive a high-cost loan than white borrowers in 2017, who received 8% of high-cost loans. So I'd like to give an example, and I think that this follows with what Jorge had really set us up for, and I really want to appreciate the National Fair Housing Alliance for identifying very specific cases in which the disparate impact standard has really been effectively applied to help protect families against discriminatory policies that are just less obvious, and that have not only protected families that have come forward and people have come forward to file a claim of discrimination, but also have actually created a standard to allow more families and more people to come forward and to state a claim. So, for example, the disparate impact standard has been used to help battle discriminatory harassment of families who utilize a housing voucher to help them afford housing. Local civil rights groups in Southern California filed a fair housing case against the cities of Lancaster and Palmdale for discriminatory enforcement against Latinx and African American housing voucher holders. The groups charged that families of color using Section 8 housing were victims of constant intimidation and harassment by housing authority investigators, sheriff's deputies, and local politicians. They eventually argued that the practices discouraged and excluded them from living in these two cities. The lawsuit eventually settled. This is just one example of one of the ways that the disparate impact standard has been applied, especially for fair housing cases. Today, 1 in 3 Latino adults experience discrimination when looking for a place to live. The community needs strong tools to help protect against obvious and less obvious forms of discrimination. Finally, I'd like to close with just a quick statement about why this is important for housing counselors to respond to. As many of you may know, especially if you are working with low-income families and Latinos and many vulnerable populations, Latinos frequently underreport discrimination. So when they do, it's critical to have strong legal tools available so that when the cases come up, they can reveal oftentimes more broader attacks and broader challenges for the community in places as small as towns and, of course, as big as state and across the federal level. So it's important for you as housing counselors to respond as you are on the front lines. Every day when you meet with clients, you get to know their issues and situations. It's important to understand, and sometimes a really great resource to know that you have strong legal tools that you can ensure that your clients are supported in this process. Look forward to answering any questions. Thank you.
Very good. Thanks so much, Agatha. So let's go to Ed Jackson at the Urban League of Buffalo. Ed, are you with us?
Yes, I'm here. Thank you, Bruce, and everybody for joining the call. The proposed rule change is something that is very concerning for the Urban League, especially when you're looking at some of the historical things that have gone on in a lot of our northern Rust Belt cities, Milwaukee, Gary, Flint, Detroit, Buffalo, for example. This is, as Jorge mentioned, this is going to make it almost impossible for a Joe Plumber type person to be able to figure out if they're being discriminated against or what have you. Like, how can anyone who's not a mathematician figure out if the algorithm is going to be actually responsible for what's the quote, Jorge, the robust causal link that will be causing them to have a higher interest rate or to be denied credit or to have to pay a greater margin. The Urban League is very concerned about how that's going to affect cities like ours, especially because even recently, as 5 years ago, Buffalo has had a bona fide redlining case that was prosecuted by the New York State Attorney General. This seems just to be against the whole concept of affirmatively furthering fair housing from our perspective. My comments are even more brief because Agatha pretty much stole everything I was going to talk about. So I'm happy to answer any questions about things that we're looking at and seeing, on our end too.
Great. So we also have Linda June here from Americans for Financial Reform, and Linda, in a previous life, has been actually litigated on these issues. So, Linda, can you give us your perspective?
Sure. Hi, everybody. So here's, I thought I'd just go through what the current framework is, and then based on the case that I brought. And so I know I'm talking to a bunch of housing counselors. So the case that I was working on in New York before coming to AFR was suing on the basis of HUD's policy of selling off all their FHA loans through the DAS program. And so the current framework, so the before this proposal, in the current world we play in, it's there's three things you have to allege. There's a neutral policy of some kind that's causing a disparity, and that's where the disparate impact comes in. Whether that's Latinos are getting higher interest rates than others, or all the families with children are having to get more housing. There's something that's causing a disparate impact. And then it's on the business to then prove that there's a legitimate business interest or some sort of reason that policy exists that's a legitimate reason. And then at that point, then the burden shifts again to find less discriminatory alternatives that would, kind of still fulfill the legitimate business interest. So that's sort of the current framework. And I say this because it's a lot simpler than what Jorge has laid out, as what they're proposing, but it's also not super easy. There's a lot of guardrails around it already. So, in our case, it was HUD selling off these loan sales. That's the policy. And what we noticed when we looked at which loans were being sold in New York City, it was all the loans were for homes in majority African-American neighborhoods in New York City. So that's the disparate impact on Black homeowners in New York. So how the proposal is really problematic. So as Jorge was saying, that you have to kind of guess a lot of things at the front end and make it impossible to bring a case. So one of the things that the HUD proposal adds is that the policy has to be arbitrary, artificial, or unnecessary. Now, I don't know about you, but I think almost every company, every landlord, every bank can have some reason, right? Whether it's there's the whole algorithm and cost thing, but there's also just most companies aren't gonna say that we just have policies for fun, right? Like that's so if I was the person being this the victim of discrimination through a disparate impact situation, I don't know how you're supposed to know this information, how you're supposed to guess at what the company might say and try to squash it at the front end. So that's just one example of how it'd be really hard. In my case, as some of you may know, the whole thing with HUD selling off loans was because their fund had depleted because of the financial crisis. And so I don't know how I would have been able to make an argument as a lawyer saying that that's not a legit, that policy is unnecessary or artificial, right? HUD is gonna just beat me down on that argument, and that's shutting down the case even before it has a chance to go anywhere, for example. The cost and the having anything that's more costly or more burdensome for the defendant be a defense. You can imagine, right? I see HUD is going to say there's no money in our thing, and the easiest and best way for us to make this money, back into our fund is to sell off these loans. Any other policy is going to cost us more money or more resources or be more burdensome. So I would have also been shut down really quickly. So those are just some examples of how this is going to be really hard. It's the way the proposal is written. I just don't think it's possible for any of us, even with a good bit of research and a good bit of analysis on the front end, to guess what the defendant might say and try to smack it down before and argue against it before the case even has a chance to get started. And one of the most important parts about lawsuits is the discovery process, which is when both parties get information from each other. And the way the HUD proposal is written, it pushes all of the burden on the front end, which means before you have a chance to do discovery, before you get to ask the company or the landlord or the bank, the types of questions and the types of information that you're allowed to get through that process, you don't even get to advance to that step. You have to, the way this skews the burden, it puts the victim of discrimination that's trying to bring this case has to come up with a theory with incomplete information, incomplete stats, and because a lot of the stuff only the company is going to have, right? And then they have to not only create a case that way, but also be prepared to argue against anything that the company might come up with as a valid reason. And so you can imagine this makes it really hard for any person, even if they're able to put together the information that say a policy is leading to higher cost loans for Black homeowners, or causing women are getting hurt in this way, and you can tell that this policy is having a disproportionately negative effect on them. Even if you got all those stats together, and that's not an easy feat in and of itself. Even if you got all of that together, you probably there's so many more hurdles now that HUD's proposal is putting in your way to even try to bring that claim and to make those arguments. So that's just a little bit of why on the litigation side it makes it really, really problematic and why everyone's saying it's virtually impossible to bring a claim. I don't know how under this proposal, I'll just close with this, if you don't have a smoking gun type of evidence or disparate, which is a whole different kind of discrimination framework, which is, explicit disparate treatment. But I don't know how you would be able to bring a claim otherwise unless if someone made it slip and said, we just don't like to rent to Latinos or something like that, which would be a totally different framework of a case. But without that sort of evidence, we have this policy in place because even though it's a pointless policy, but we want to keep all families with children out. Right? I don't know how you would bring any other type of discrimination claim if HUD's proposal goes into effect, which is why both as a lawyer and now as an advocate in DC, I'm very, very alarmed.
Thank you, Linda. So let's talk nuts and bolts about what it is that we can do as housing practitioners to help defend disparate impact. So Jorge, what's the strategy here?
Absolutely. So thank you all for sharing your insights on why this is such an important thing for folks to be engaged in. So the National Fair Housing Alliance has partnered with a number of other civil rights organizations to essentially create a campaign called Defend Civil Rights. And we chose civil rights instead of defend fair housing because of what I mentioned earlier about the plans that this administration has to utterly decimate the ability to use this doctrine in every other civil rights statute. So this is something that we've been working on for some time now. Our central goal is to delay the process as much as possible. Look, I'm going to be completely frank with everybody. We cannot convince Donald Trump and Ben Carson and the folks behind them working on these types of policies to become better people. So the most effective thing that we can do is to submit as many comments as we can, attach as many materials as we can to those comments, and force them to spend as many hours as we can reading those and responding to those in the Administrative Procedure Act process. And that's really important because our goal here is to ultimately draw this out so far enough that we will not have a final proposed rule, that we will not have a final rule that looks anything like this, or a final rule at all before 2020, which we're hoping might produce different outcomes than the previous election. So the campaign is called Defend Civil Rights. We have a website called defendcivilrights.org. There you will find a comment portal where you and anybody else, including your clients, if they so choose, can spend 1 to 5 minutes to submit a comment where they say why Fair Housing is important. Once you click submit comment, that actually gets sent to OMB, to HUD, and it becomes something that has to be counted and responded to by HUD in the administrative procedure process as they continue with the proposed rule once the comment deadline closes, and that is October 18th. That is next Friday. So we have this campaign, we have this website. We also have a Google Drive, Google folder, which we are not including with a ton of materials. One advocate that I shared it with described it on a different call as a treasure trove of materials. And that's because we have template comments for tons of communities written by advocates working on behalf of women, families of children, environmental justice, transportation equity, consumer rights, etc. We also have a number of different kind of fact sheets. They're not quite exactly like normal fact sheets, but what they are background documents on how the use of disparate impact has been helpful to defend the rights and to achieve justice for those same communities and other communities that I haven't mentioned. We also have an extensive communications toolkit that has kind of the basic framework for our messaging, as well as draft tweets that you can use, shareable graphics, template letters to the editor, template op-eds. We also have material that explains in further detail the exact changes that this proposed rule would make to the way that disparate impact claims are brought forward if it were to be finalized. You name it. We have a ton of material on this Google folder that I'm hoping folks will take a look at and share with trusted partners and use to submit your own individual comments. Now, submitting your own individual comments is extremely important, and as I mentioned before, we are trying to delay HUD as much as possible so that we can keep them from finalizing the rule before the end of this administration's term. So ways that you can do that include helping to drive people to the defendcivilrights.org website, using the hashtag #DefendCivilRights on your social media, after taking a look at the communications toolkit, engage in direct outreach and raise public awareness. And you can do this on Twitter, on Facebook, prepare op-eds, etc. But I think between now and October 18th, our absolute goal is to encourage everybody to submit an individual comment and to share those materials that we will share with you, with your trusted networks locally and regionally and nationally, to do the same. And just a little bit about the comment template letters. These comment template letters are kind of framed from the perspective of the organizations that helped produce those templates, and that's because we want to make sure that every kind of issue organization or issue coalition has the agency and feels the ownership necessary to really take this issue on as their own, because it is their issue. This is everybody's issue. And so because of that, each template is going to be a little bit different, but ultimately the goal in each one of those is to provide relatable local or personal or organization specific or regional specific information to kind of additionally add to the kind of stock language in each of those template letters. And that's important because a comment letter to HUD on this issue will not be considered a unique comment letter if any less than 20% of the content in that letter is unique. So essentially, you'll see in all of these, there are like bracketed areas that have language in there that gives you recommendations about how to, kinds of things to focus on, the kinds of things you can bring in from a local perspective, et cetera. And that's all highlighted to ensure that each one of these letters is considered unique by HUD. And the last thing I'll say is that, we are happy to help in any way that we can. We hope that the resources that we've provided can be of use to you. This sounds like a very complicated issue, and quite frankly, it is. It's extremely difficult to bring a successful disparate impact claim as it is right now. But as one of our colleagues here at the National Fair Housing Alliance said at our current in-service training program, which I'm at right now in Baltimore, the way that HUD has proposed this rule essentially requires that any successful disparate impact claim effectively be an intentional discrimination claim. So you have to prove so much at the front end that you, in essence, are already able to produce a claim that is the same as an intentional discrimination claim. So if this rule becomes a final rule, there is no way that we will be able to challenge these different inequities in our systems that we know we need to continue to work on. And I want to say one last thing. Folks on the call work a lot on housing, work in a number of different housing area capacities. And I want to say this. Right now, we are undergoing a dramatic change, or at least attempts to dramatically change the way that the housing market works right now. We have proposals and reports from the Treasury and from HUD on how to change the GSEs and how to change the secondary housing market. We have efforts from certain regulators of the Community Reinvestment Act proposing reforms to the Community Reinvestment Act that do not work and that undercut the affordable housing goals of the CRA and our ability to fully enforce our fair housing and fair lending laws in this country. And we have this proposed rule that is setting up a scenario in which all of the housing market actors in this proposed new housing market system that the Trump administration is trying to make a reality will no longer be held accountable for the discrimination that we have seen them perpetuate over and over and over again. So this is something that is existing in a perfect storm, and we need to understand this in that context. So please engage, #DefendCivilRights, defendcivilrights.org. My name is Jorge Soto, and I'm with the National Fair Housing Alliance. I hope you have my email. I'm happy to help in any way I can.
Thank you very much, Jorge, and thank you everybody who presented here. So on the resources that Jorge just mentioned, the Defend Civil Rights website and the treasure trove of a deeper dive in information, both of those links were in the email I sent out this morning about the call. So we have the agenda, and right below it, you'll see the links to those resources to make it easier for you to do this. I think the big takeaway here is that we need to have, everybody needs to do their own unique comment and submit it to through the portal that you can get through Defend Civil Rights, and that it should just you can use the resources that are there, they're available, but you want to make sure that there's a lot of unique wording that you're providing in it. And short comments are not a problem, but if you can go into length, that's always helpful as well.
And Bruce, let me say one last thing about that,
if that's
please.
Okay. That's good.
Just to clarify. So the portal on defendcivilrights.org is really intended for folks who don't have the time, or who maybe don't have just the expertise or like the basic knowledge about housing to be able to still get their voices heard. But if you want to submit something that is more that is template based, like what's in the Treasure Trove Google folder, you can we have in that same Google folder instructions on how to submit a comment to via regs.gov. So there are two different options to submit. One is more for folks who are not have not really done a deep dive on housing, but still know that this is something they care about and want to say something. The other opportunity is something that's more robust. So we have a couple different options there.
Good. And do we have questions? So we're good on this. So I think we're going to say thank you very much. This was very helpful. Appreciate all the presenters, and thank you everybody for joining us. We will. I think Melody's working on our comments, so we'll be submitting as well. Thank you, everyone.
Thank you so much.
Thank you, everyone. Have a great day.
Thank you.
Thank you.